Good Sunday afternoon, everybody. Welcome back to LTL True Crime. We're here on the verge of 2024. I want to welcome everybody in to this early Sunday edition live show. I have actually a very special live plan tonight. We'll be getting some updates on Chelsea Grim's case. It's a case that's very near and dear to my heart. And I know a lot of you, if you don't have plans, will be over here watching. If not, you can catch it on the replay if you've been interested in that case. I just want to see everybody here in the chat room. Thank you all for being here. And Happy New Year to everybody. I hope that 2024 is everything that you want it to be. We have literally been bogged down the last 3 years, and I feel like we're at the end of that hump. We're over all of that. I think 2024 is going to be an amazing year for everybody, and I'm feeling the positive energy for 2024. And we have to stay positive. And the most positive thing that we have to stay positive about right now is the Karen Read case and the Karen Read hearing that's going to be on the 5th, this Friday. And I know that there's going to be tons of supporters there. This is becoming a huge national attention case. It's getting the attention that it needs. And, you know, the driver behind all of that is you, Turtleboy, and the movement, the Free Karen Read movement that is pushing this whole case along and getting it out there into the national spotlight. It's what we need right now. We need positivity in it. We need to keep showing up to the hearings, showing up in full force, peacefully protesting, wearing your shirts, wearing your gear, making sure that you're at your standouts, taking part of the conversation in the Discord groups, you know, the Facebook group. That's what you need to continue doing, supporting this cause. And I don't want people to lose sight of that. It's very, very important. It's very important. And that's what we need right now, to stay together. We don't need inter-fighting. We need to stick together. And that's what this is all about. So I have a couple of things that I want to get into today. I know, like I said, it's an early stream. Most people will probably watch this on replay. But I want to keep continuing to educate, because I know that all of you know about this case. I know all of you know what's going on. And I all know that you know that Karen Read did not do this and that Karen Read should be free. So what I want to do is another educational stream today. And I need all of your help, because if there's new people that are in this chat today, we can explain when they ask questions. We can inform them when they ask questions. So what I want to do is pull up a post that came out the other day. This was via the Turtleboy Facebook page, Justice for Karen Read and John O'Keefe. was the announcement about the court hearing that will happen on Friday, January 5th at 7:30 a.m. That's when they would like uh, the rally to begin. So it says, join us at the Norfolk Superior Court, Dedham, to peacefully protest at Karen Reed's court hearing, and the hearing is at 9 a.m. I will be there. I will be in support. I will be reporting on this story. I'd love to talk to some of you. Come up to me, seek me out. Let's have a conversation. Maybe I can get some interviews with you all and find out what got you involved. Why are you standing behind this movement? Why is it the way that you feel? And maybe there's some people there that oppose this. Maybe there's going to be some people there that think Karen is guilty. Come talk to me. Let's hear your side of the story. I'm here to report that. I want to know. We all want to know. Paula F., new member. Thank you so much for supporting the channel. I appreciate that. So let's continue to educate. Let's continue to let people know what's going on. We need to continue to grow this movement. Yes, we have our biggest rally king, unfortunately and falsely, in jail right now, but we still have power. We still have power to push the Free Karen Reed movement along. And that's exactly with what Aiden would want all of you to be doing right now, to join together, band together, and be as one. So we had that announcement. And then shortly, just after that announcement, we had an announcement by Turtleboy himself. And I will read this, and I'm sure that you all have read this already, but just for the audience that's new here and is finding out about this. So it says, tonight is my 5th night in jail. The first 48 hours, I was depressed, and I was on the verge of tears constantly. I was not myself. Today, my parents visited me, and every day, hundreds of Turtle Riders send me positive messages of encouragement. Keep them coming, especially the videos. I love the videos. I miss my kids dearly, and it breaks my heart to be away from them, and I'm no longer pessimistic. I will get out of here one way or another, and I have a new outlook on life. The CEOs here are great, and people have treated me well, and I've always had tremendous respect for what they do. I will cry and hug a lot of people when I get out of here, but I will be stronger for this. And I am an Eagle Scout and a member of the Order of Arrow and earned my Wilderness Survival Merit Badge. I'm proud product of Worcester's public schools. They cannot and will not break me. We have big things coming, but I also ask that you stay focused on justice for Karen Reed, the Canton Nine, Janelle, of course, and John O'Keefe. We are all in this to fight together. And quote, we ain't got no quit. Let's see a big crowd for Karen on Friday. I will be there in spirit. Aiden Carney. I'm going to be honest with you. It takes a lot to say what he said. It takes a lot to admit what he said. He put his most vulnerable moments out there and said, look, I cried. We're human beings. We cry. We hurt. Yes, we stand behind those huge, thick walls to not let people beat us down, but it happens. And maybe this has given him a new outlook on life. Life does not stop. It continues and it changes every single day. And it's with what the direction that your life comes in that you can grab, take hold of it, and take that and decide where you want to go with it. But I think we need to stay positive, continue to push this movement forward, be there on Friday in support. There's going to be a lot of people there. I'm going to tell you, it's going to be a lot of people. This will be national news all the way. But let's do it peacefully. Let's stand out there and support. Okay. So what I want to do here is, before we move on to that, I have a quick piece of business that I want to settle as something has come up over the last 24 hours and it's out there and it's public, but I think it's something that I need to read and move on from and extend a bit of an olive branch. I was getting many emails this morning of people being concerned, and we'll clear that up right now. I think with this out there, so just bear with me one second. I need to address something, and I want to address it in a way where we can all move on as a community together. So I wrote something here on my community page this morning as there's been a little bit of a, I guess, ruckus or beef between myself and another creator over the last couple of weeks. And I just want to make sure that everything is clear and that her audience understands and my audience understands that we can move on in a positive direction. But I wanted to make sure that everybody understood where I was coming from. So let me just read through this. Once I read through it, I'm past it. I don't want to hear about it anymore. I have moved on, and we'll just go from there. So I wrote, "Good morning, LTL fam. It has become aware that some of you are curious about my statements during last night's live regarding my recent outspokenness about Tanya from the Titanium Built YouTube channel. Several months ago, I discovered Tanya's channel and began openly cordial, inviting her to join my chat during our shared interest of the Idaho 4 student murder case. My goal was to build a community of true crime enthusiasts, finding strength in numbers and banding together with a few other creators." Give me 2 seconds. Let me just do some housekeeping. I go on to say, as we collaborated in a few live sessions, some of those creators wanted to branch off and go back to their own channels. Tanya went back to her channel, and although we continue to have great lives afterwards, she eventually desired to go solo again, which is perfectly fine. However, emails from fans of both channels started pouring in, noting similarities in topics, thumbnails, and titles and language in her presentations. Initially, I brushed it off, understanding this is part of live streaming's world's nature. Yet a critical moment came on December 7, 2023, when an email from a viewer of both channels pointed out a concerning incident. During her live stream about the Chelsea Grim case, Tanya presented Chelsea's case file word for word, claiming it to be her own handwriting. It was basically typed with a watermark on it, despite admitting that she didn't possess the case file during that live. I had presented it 3 weeks prior, and it was exclusive to my channel. Feeling upset and robbed of the trust I cultivated through hard work, reaching out to people involved in Chelsea's case, having them as a guest, dedicating hours to the presentations and obtaining case files, also the hours of the work of my assistant had put into helping obtaining information, I contacted Tanya. She admitted taking notes from my video, which was disheartening. My encouragement in the form of super chat during one of her lives was for her coverage of Chelsea's case, was not my invitation to take my work and pass it off as her own, but I suggested to keep the case alive. Furthermore, last night, she criticized my coverage of Karen Reed's case, dismissing it as crama, known in the community as crime drama, despite it being a case 20 minutes from where I live, with many questions that need answers and supported by a wonderful, dedicated, free Karen Reed community. Karen Reed's case holds immense significance in our modern era, potentially impacting our justice system profoundly. I'll leave you with this thought. I'm going to be the bigger person here as I extend an olive branch to Tanya. It's time to move on. Jealous people don't take others' work and pass it off as their own. It's about innovating and setting trends. And personally, I don't care how much your furniture costs, but I'll echo your sentiment. Let's concentrate on our respective paths to sidestep negativity that hampers our community and the cases that we follow. Remember, this is not about us. It's not about us. It's about the victims, the communities, and families seeking justice. I genuinely wish, Tanya, the best in your future. Good luck. And here is my olive branch. I am done. I have moved on. And I hope that you will too. Thank you for listening. Okay, let's get back to the topic of hand, the most important thing, why we are here. So what I want to do is, if anybody has not heard Karen, I'm going to play a interview with her back about 4 months ago from ABC News. This is probably one of the only interviews that I could scrub and find of Karen publicly talking about what is going on. So we're going to play this. We'll educate the audience. And then what I want to do is the most important thing, and the most important hearing that I think so far is the May 5th hearing that Karen had. I want to play that for the audience so they can understand and get the education from where her team stands versus what the state is saying. Unetti and Jackson are amazing in this video, and it's gonna show you a lot of things and open a lot of eyes here. So let's play this first. We'll get into the hearing, and then I actually want to talk about at the end the federal probe that we now know of. Let's see. Scott says, "Great words, Brian. Thank you." Wendy, class act. Thank you so much. Carrie H, well said, perfectly worded. Yeah, I'm done. I've moved on. We're done. It's out in the open. She has said things. I have said things. I want to be the better person here, because letting this stuff get in the way of what we're trying to do and create on our respective channels is not going to help anything. So let's just move forward. The olive branch is there. I will no longer speak about you. I hope that you will no longer speak about me. And that's it. I'm done. I'm over. It's over with. It's water over the bridge. Good luck on your channel. Liz, great job. Thank you. Okay, let's move on. We're done. We're over. It's in the past. Exactly. It's in the past. Okay, let's play this because this is the most important thing why we're here today.
Outside this courthouse in Canton, Massachusetts, supporters swarmed around Karen Read, charged with murder in the January 2022 death of her boyfriend, Boston police officer John O'Keefe. Read has strenuously denied the allegations.
I did not kill John O'Keefe. I've never harmed a hair on John O'Keefe's head.
Her defense, bare-knuckled and bold, is making national headlines. Her lawyers alleging in court documents that a fellow police officer was involved in O'Keefe's death and colluded
It wasn't the 5th, it's the 3rd, and I apologize. I come corrected. It was close. Sometimes I do so many cases that sometimes dates and times and all that get mixed up. I come corrected. It was the 3rd. I said the 5th. It's corrected.
With other people in a cover-up.
We don't live in a
You're
perfect
alleging
world.
that law enforcement officials in this state committed murder and that they're covering it up. Why would they want to be involved in this?
Because he's dead. I think things went too far. It was late. There was alcohol involved, but they're all family. And there's many of them involved.
After posting bail, Read has spent much of the past 18 months in and out of court, awaiting a trial date.
And me and my family and my attorneys and my team have marshaled every resource to get to the truth. It just feels like no one else wants it.
Prosecutors allege that Read hit O'Keefe with her car after getting into an argument earlier in the day, leaving him to die in the middle of a snowstorm in January 2022. But Read says she had no reason to harm her boyfriend.
I would call him the patron saint of Canton. He was just very selfless, frugal, and I think you'd be hard-pressed to find anyone that didn't care for John.
The couple first dated in their 20s and reconnected more than a decade later in the middle of the pandemic.
So how did you meet up again?
He had reached out to me on Facebook and he said, "Hey, blast from the past, how's things?" And when I saw his picture, his profile picture was with several young children. And then it triggered my memory that his sister and his sister's husband had passed away. And he told me, "Yeah, I have the kids now." I admired that. I thought that was amazing.
Soon, Read says she became part of the family, often sleeping over at O'Keefe's house and helping take care of the kids.
He would go to work and I would stay with his niece and nephew. All of the breaks that the kids had, we did something.
But their relationship also had its struggles. Reeves says O'Keefe had been relying more on her to take care of the kids and that he criticized some of the decisions she made with them.
We had had an argument on New Year's Eve. We were away on vacation, and he became incoherently drunk. And I ended up ringing in the new year with his niece and nephew. John didn't come back to our room till after 3 a.m. So that was rough. I felt very much taken advantage of. He apologized profusely for what happened on New Year's Eve. And he said, if you can't get over it, then you need to spend some time at yours. I can't keep apologizing. I don't want to keep rehashing this.
A few weeks later, they were invited to meet up with some friends at the Waterfall Bar in Canton. And there, they ran into Brian Albert, a fellow Boston police officer who Reed says O'Keefe looked up to. Albert had led the city's gang unit before commanding the Fugitive Apprehension Team. It was the elite squad responsible for taking down some of the city's most dangerous criminals and featured in the 2013 TNT show, Boston's Finest.
1 minute we're walking around, everything's fine, and then 1 minute it's not fine.
Both times I met Brian Albert, he seemed like the type of person that you'd be surprised he's out socially because he doesn't seem like he ever wants to be there.
But at the bar, Reed says there was an invitation to continue hanging out at
Welcome in,
Albert's home.
everybody. Happy New Year.
I said, can we make sure we're welcome here? Nobody extended the invite to me. I didn't hear the invite extended to you.
They drive to the Alberts' house. What happens next is disputed.
So I pull at the foot of the driveway. It's snowing. John has no coat on. It's windy. So I drop him off. He goes up the driveway.
That's something that I've always been curious about. And I'm glad that this got answered because, again, this is, a lot of this is I'm still learning a lot about this case. But she says that he had no coat on, and that made a significant difference in those abrasions on his arm. Because I always wondered, was he wearing a coat? And I'm so glad that she cleared that up in this interview.
And approaches the side door. And as I see him approach the door, I look down at my phone.
Reed says after about 10 minutes of waiting in her car, she became irritated that O'Keefe still hadn't gotten in touch with her. And she drove back to his home where she continued calling him before, she says, she fell asleep around 1:30 in the morning. She then says she woke up before 5 a.m. He still wasn't home.
Yeah, that's true,
She then
Mary.
started
I
canvassing
knew
the
know about
neighborhood.
that too.
gonna-
Thank you.
Drive around in the 2 square miles that we spent the preceding night.
After 20 minutes of unsuccessful searching, she called John's friend, Carrie Roberts, and Jennifer McCabe.
Now, let me ask a question. Where was that verified? Is that in the police report? Or where did you hear that? Because that's new to me.
Brian Albert's sister-in-law, who was also at his house the night before. The three women together now headed to Albert's home.
How soon was it when you pulled in there that you saw John's body?
Where do we know
Immediately.
about that?
And what struck me when I saw him was his mouth was open a little bit and his eyes were shut and he had spots of blood in different areas on his face.
O'Keefe was taken to the hospital and pronounced dead. He died from blunt force trauma and hypothermia. And it wasn't long before Reed became the number one
Thank you, Street.
suspect.
I'll have to go
Authorities
back
say
and
they
look.
had noticed a cracked taillight after they
Excellent.
seized
Thank
her
you.
car.
I had told both Jen and Carrie that I cracked my taillight. I said I just hit my car on top of everything, but I didn't look at the damage. And
Thank you.
both women said, it's cracked. It's cracked. Calm down. You cracked your taillight. You're okay. Let's go look for John.
But according to police statements, Jennifer McCabe told authorities that while they were looking for O'Keefe, Reed stated, "Could I have hit him? Did I hit him?" And when O'Keefe's body was discovered, first responders who arrived on the scene say they overheard Reed make other statements.
Firefighter said that you said, I hit him, I hit him, I hit him.
I said I hit him. It was preceded by a did and proceeded by a question mark. What I thought could have happened was that did I incapacitate him unwittingly somehow and then in his drunkenness passed out?
When you walked out of the bar, how many drinks had you had?
I had had probably about 4.
The Commonwealth says that you had 9 drinks that night. That's what the prosecution says.
I don't believe they're saying I wasn't in my right mind.
Well, they were saying you were intoxicated. Is it possible that you might have hit him unwittingly in your admittedly very large SUV?
No, not possible.
3 days after O'Keefe was found dead, investigators arrested Reed for manslaughter. She was eventually indicted on second-degree murder. Investigators reported they found fragments of broken glass on the rear bumper.
She must have been like, what the fuck? Like, out-of-body experience when they came to arrest her. She must have been like, what is going on here? Like, what is going
on Reed's vehicle, and that a broon cocktail glass was found by what appeared to be patches of blood near O'Keefe's body.
The victim, Mr. O'Keefe, is last observed on surveillance video with a cocktail glass in his right hand. Same arm that's injured, the same type of glass that is then recovered from the bumper of the defendant's car.
In court documents, the prosecution also claims that Reed's blood alcohol level could have been between 0.13 and 0.29%, above the legal limit of 0.08. In addition, they say pieces of Reed's taillight were found on the scene the day O'Keefe's body was discovered. More fragments of that taillight were found the following week, according to Canton police reports.
Now, come on, dude. The following week. Remember, it's the fairy dust, the magic fairy dust. Just sprinkle it. What is it, like the Dave Chappelle comedy? Just sprinkle some crack on it. It'll be okay. Right? Just sprinkle some crack on it. It'll be all right. Just sprinkle some taillight around. It'll be okay. Come on, dude.
After
A
the
week
snow
later,
melted,
bro.
which revealed more at the scene. But Reed's attorney, Alan Jackson, has a different theory about how those fragments of taillight got there.
Those pieces of taillight were placed there after the fact.
You're saying evidence was planted.
The pieces of taillight were planted after the fact.
What does the defense believe actually happened to John after Karen dropped him off?
I think he walked into the house. I think he was confronted, was likely brought down to the basement. I think that confrontation got physical and he was beaten. He was beaten to a point of unconsciousness.
Jackson argues that the autopsy photos of O'Keefe support his theory and not the prosecution's claim.
Looks like he's been in a fist fight and he's been beaten. He's got some defensive wound bruises on the backs of his hand.
Thanks, bro.
He's got this massive laceration on the back of his head, a big giant gash, about 2.5 inches, exactly lateral, going from left to right. 2 black eyes, cut over his right eye, cut over his nose. This was a cover-up that John was murdered inside that house. His body was placed outside.
But in a statement to ABC News, the prosecution says there was no conspiracy or cover-up. Such claims have been systematically refuted by evidence submitted to Norfolk Superior Court. The prosecution also said that, according to O'Keefe's cell phone GPS records and 11 witness statements, O'Keefe never entered Albert's home, and that a medical examiner found no signs of Mr. O'Keefe being involved in any type of physical altercation or fight.
There was no evidence that Mr. O'Keefe was beaten and left for dead. There was no evidence of any defensive wounds.
ABC News reached out to
Yeah,
attorneys
just the
for Brian
bruising on
Albert
his
and Jennifer
fist.
McCabe, but did not hear back by the time of this broadcast. In a previous statement to the Boston Herald, McCabe's attorney said the whole scenario is baseless. Reed is scheduled to appear next in court again in September.
All right, let's continue to educate here. I think one of the most important things that we can watch right now is the hearing from May 3rd, this past May. We'll get everybody caught up to speed. We'll educate. And then I have a little video about the federal probe. Listen, I appreciate everybody being here this Sunday afternoon. I realize it's Sunday afternoon. A lot of people have things going on for New Year's, but we have to continue to be positive. We have, less than about a week away from where the Karen Reed hearing will take place. I know all of you will be there. I'm going to be there documenting everything, talking to everybody, getting their point of view out there. And, I think that it's going to be an amazing day of support. The Glare checking in. What's up, dude? How are you, man? Hope everything's well. I've been catching your lives. You're killing it over there, bro. And I hope you have a happy new year as well. I'm going to be live tonight after my 8 o'clock live. I'm going to spark it up at about 11. If anybody's around, come hang out. Just going to watch the ball drop. That's it. We can throw out some topics up there, but any of the creators that have come on and they want to pop by, pop in the chat. I'll drop the link. We can hang out, whatever you want to do. If not, you got plans, please be safe. Don't drink and drive. Let's be smart about what we do. If you need to drive and you've been drinking, get an Uber, call a friend, call a rideshare service. Let's be smart in what we do because we want everybody to come back to these lives, and enjoy this content and keep this movement going. I don't want to see anybody get hurt. I don't want to hear about anybody getting hurt, stuff like that. So you're all welcome here. Again, Will, if you're around later and you want to pop on, I'll be live for about an hour watching the ball drop. If that's what you do, come hang out. Tom's by, can jump on. Anybody. We're just going to hang out. Nothing stressful. But thank you for the $9.99. I appreciate it, bro. Thank you so much for the support. And go check out The Glare if you haven't. Subscribe to his channel. He does a lot of Karen Reed support content over there. All right, let's get to the May 3rd hearing. I think it's very important. Again, we have a lot of people in the chats that are new to this case, and they need to understand and be educated. That's why I need all of you in the chat to answer the questions or put the facts out there in the chat. Let these people know what's going on. All right, here we go.
Good afternoon, Your Honor. Attorney David Yannetti and Attorney Ian Henchy from the Yannetti Law Firm. Good afternoon, Your Honor. Alan Jackson from Worksman Jackson and Quinn, along with Elizabeth Little from Worksman Jackson and Quinn on behalf of Karen Reed.
Good afternoon, Mr. Jackson. Good afternoon, Ms. Little. Good afternoon, Ms. Reed. Okay, so we're here for the Rule 17 motions. Who's going to argue those?
So, Your Honor, there are two motions before the court that we'd like to be heard on. One is the motion to renew our motions to compel, which we'd like to be heard on first, if the court pleases. And I would be arguing that motion. With regard to the Rule 17 motion for the animal control records, my colleague, Mr. Jackson, would be arguing that second, if the court pleases.
Okay. All right, I'll hear you.
Thank you, Your
This
Honor.
is
May
the
I
dream
report?
team. This is the dream team. The dream. I cannot wait until cross. I can't wait until cross-examination. It's going to be amazing. The show that's going to go on is going to be, people's mouths are going to drop of how great these two attorneys are together. The power force that they're going to have in that courtroom is going to be unbelievable. Unbelievable.
We are seeking immediate access to John O'Keefe's clothing, to all evidence seized from my client's vehicle, to tissue and other samples from John O'Keefe's autopsy, and to the original Canton Library video, which we still do not have. We are asking this court specifically to set a hard deadline for access to this mandatory discovery and evidence. Your Honor, at the outset, it is important for me to emphasize why a deadline needs to be set. It's important to emphasize why time is of the essence for our access to this evidence. It's been 15 months since my client was arrested and falsely charged with killing John O'Keefe. Prior to 15 months ago, my client was employed in two prestigious positions. Prior to 15 months ago,
yes,
she had a
let's not forget
robust
Eliza
health
Little as well,
insurance
too.
plan that covered
Brilliant.
her numerous serious medical conditions. But 15 months ago, she lost everything. 15 months ago, these false allegations began to destroy her life. And for the last 15 months, she has been fighting for her life. 15 months after her arrest, she has no income. She does not come from a wealthy family. Her father was a respected and now retired educator. Her family is very...
I would think yes. I know Court TV is going to be there. And I'm sure Boston 5 will be down there. 25 will probably be there. So I'm sure we'll get some type of live, if not recorded and then replayed. There's going to be a ton of people there. So, just be prepared. I would assume dress warm. Hopefully we keep getting these warm temperatures that we've gotten, so we're not out there freezing our asses off. But again, I'm excited to be there. I just ordered a brand new camera a couple of weeks ago. I'm excited to get to be able to use that and document everything that's going out. I was going to try to live stream, but the last time I live streamed down to the court, it was complete trash. So I'm probably just going to record everything, come back, edit it, and get it out, and then do some commentary over it later in the night or later the next day. So that's kind of my my plan anyway.
Squarely middle class. But given that Karen Reed is now fighting for her life, whatever money that they've saved is all going to her defense in this case. She's hired private counsel from two coasts. She's hired multiple experts at considerable costs. And when I say considerable, I mean tens and tens of thousands of dollars. And the meter is running with each passing court date. She can't afford to scrimp on her defense because her life is at stake. In the 11 months that this case has been pending in this court, we have continually asked for access to the same basic mandatory discovery evidence. We've been prohibited from inspecting that evidence. In February of 2022, the police seized John O'Keefe's clothing. It's now May of 2023. We haven't seen it. We haven't inspected it. We haven't been able to test it. In February of 22, the police seized pieces of taillight from my client's vehicle, pieces that they claim to have found at the residence where John O'Keefe died, despite the fact that multiple searches initially turned up nothing. Pieces of the taillight were only found after Trooper Michael Proctor, conflicted Michael Proctor, had seized my client's vehicle and had it in his possession for well over an hour. That evidence needs to be put to the test, and it needs to be put to the test now. We have been prohibited from testing it, from inspecting it, from even seeing it. There were tissues and other samples from the autopsy of John O'Keefe to which we've been denied access. We believe that when those samples are tested, the results will be exculpatory.
No, I'll be outside.
Case ending. But 15 months after
my sole purpose there on Friday will be to interview and talk with people outside, and then obviously when Karen comes out, if there's any type of press conference, I want to be able to record that. I want to be able to get there when she arrives at court and we see her going into the courthouse. So no, if I go in the courthouse, it's literally just gonna bog down my time to make content. I could always go back and watch the hearing when I get home, or at least listen when Karen comes out if there's any type of press conference. So that's my purpose of being there. I want to get the crowd's reaction, everybody's reaction, interview and talk with people, supporters from both sides. Maybe, obviously there'll be a lot of people there supporting, but maybe there's some people that are not supporters there, and they can kind of share their side of the story and let us know why they feel that Karen is guilty. And I want to hear from people that feel that Karen is innocent. So that's kind of my purpose there, to tell both sides of the story, to get the reaction of everybody there, to film what's going on in the area. And that's how I'm going to approach it. So
she was arrested, and 11 months after she was arraigned in this court, that evidence remains hidden from the defense. The police have maintained exclusive control over the event data recorder and the Lexus infotainment system from my client's vehicle. We have seen neither, and this is simply unacceptable. Prohibiting the defense from inspecting this evidence is infringing on my client's constitutional right to a speedy trial, and it's infringing on her right to due process. It's almost 3 months ago that we last appeared before you, Your Honor. We requested access to these items, and yet again, the response from the Commonwealth was that they would be tested soon. The prosecutor had represented within 30 to 60 days. That's on record. It's now close to 90 days. We've made zero progress. This court did order that the Commonwealth request expedited testing, but that order has yielded nothing. I asked the court to set deadlines then, which the court was not inclined to do. 3 months later, it is crystal clear that deadlines need to be set. Without a deadline, we have no assurances that this case will not drag on who knows how long into the future. With each passing day, my client, who not only is presumed to be innocent, but is factually innocent, remains jobless, with inadequate health insurance, and with each passing day, her savings and her family's savings continue to be depleted. There is no time to wait. There is no time to waste. It is time for excuses to end. As we noted in our motion, the prosecution and the crime lab move very quickly when they want to. In other cases pending before this very court, the very same investigators secured DNA testing within 2 weeks of opening their investigation before anybody was charged. Contrast that with our case, where here we are 15 months later, no such testing has even started. Regarding the Canton Library video, this court should know we still do not have relevant time periods. From the Commonwealth's evidence, we know that my client drove by the Canton Library at 12:16 a.m. on January 29th because that was recorded. There is video of her driving by at that time, heading to 34 Fairview, which is where John O'Keefe died, with her taillight intact. We know that my client arrived back at John O'Keefe's residence at 1 Meadows Ave in Canton at 12:41 a.m. because the Commonwealth produced a voicemail that she left for John, where you can hear the garage door closing, the car door closing, the house door closing while she walked in her high heels on the garage floor. One Meadows is about a mile from the Canton Library. We know the video equipment was working because they have that footage from 12:16 a.m. But in the video that the prosecution turned over to us, there is a gap in that video from 12:37 a.m. to 12:39 a.m., which would have been the precise time my client would have been driving back past the library. We know that that footage would show that my client's taillight was still intact at that point because she never struck John O'Keefe with her vehicle. Yet the prosecution has produced a video from the library with that crucial time period missing. This evidence is strictly in their possession. We've been told that the Canton police provided the evidence to them via a share file. I'm sorry, the Canton Library provided this evidence to them via a share file link with a guest ID and a guest password. We need that link, that user ID and that password. We cannot rely on Trooper Michael Proctor, conflicted Michael Proctor, to sanitize.
I'm just trying to sit back and let the lawyers talk. You know, I want to educate anybody that's new here today in this chat or new to watching this case and getting in tune with it and understanding what happened. And, you know, if they're watching live or on replay, that's the most important thing. We need to go back over this and keep continuing the positive message and let people know what's going on. You know, that's my style. Everybody else in this creator space that's covering Karen Read, they all have their different styles. I want to educate. I want to show people. I want people to get involved. I want people to get behind the Free Karen Read movement, as they should. As they should. All right, let's keep continuing here. Yannetti on fire.
Sanitize exculpatory evidence before sending it to us. We need the original footage. If the Commonwealth answers that that original footage no longer exists, then we'll need an evidentiary hearing to put the relevant parties under oath to find out what happened to it. The bottom line here, Your Honor, is that we've spent 15 months trying to uncover the truth. We are not afraid of whatever evidence is unearthed from whatever source, because for 15 months, every stitch of evidence has been consistent with my client's innocence.
Awesome.
However long this case lasts, and I sure hope the prosecution comes to their senses and realizes they have no case because they've charged the wrong person. But however long this case lasts, the remaining evidence will drive a stake through the heart of this prosecution.
Yeah, that's Aiden right here.
In the meantime, my client suffers. In the meantime, her life is on hold while she spends every waking moment defending herself emotionally, intellectually, and financially. We cannot abide by excuses any longer. We need this court's help. We need you, Your Honor, respectfully, to hold the prosecution's feet to the fire. We need this court to order the Commonwealth to stop trampling on my client's rights to a speedy trial and her right to due process. We need this court to set deadlines for the production of this evidence.
See, it's strange in this case, and I want to just kind of reference another case that I followed, but let me just pull this up really quick. Brendan saying, I love how everyone's different styles all work together so well. The day where everyone ends up streaming without really stepping on each other's toes, much feel like a whole Karen Read festival, haha. And that's the thing, is that I would love to, and I'm not sure if Glare is still watching me. Will, if you're still watching me, Tom, you're still watching me, and the other channels, Mike from Young Jerks. And again, there's some other channels that follow this, Making Law Simple, and a couple other channels. And forgive me if I'm not getting everybody, but I would love some time if we can all coordinate and just kind of not step over each other, because I want to give everybody their respective space. Like the other day, I had an earlier stream planned. I was going to go at 4 o'clock. Mike from Young Jerks went a little bit before me. I gave him a space. I backed off as he had things to say. And we all have different things to say as different creators. Our minds all work differently. But I would love some type of communication where we're not kind of stepping all everybody, so everybody can get everybody's full message. Again, it's your channel. You can go whenever you want. I can't control any of that, but I like working with people versus against them. I typically go at 8:15 p.m. Eastern Standard Time. I can work around that. I'm willing to work around that. And my channel is always open to any of those creators. If you want to come on, hang out, tell me your side and your vision and your message in the Free Karen Read movement. Obviously, obviously the door is open. I've had Tom on, I've had Will on, the Glairer, and you know, I'd rather work with people than against them. And that way, and if the creators are watching, another thing that we can do as well too to keep this movement moving, and I don't know if you all know this, but there is a way that we can all collectively connect our streams. So if someone was going at 4 o'clock, someone was going at 8 and 11, you can all collectively connect your stream, and it just keeps bringing that audience over and flowing through. Again, it's not my channel, but I love working with people versus against them. So if you want to work with me, again, reach out. Let's talk live podcast at gmail.com. We can get on a little bit of a schedule or whatever. It's completely up to you. If not, I got to just keep doing my thing for my channel. I get it. You have to keep doing things for your channel. Completely respect it and understand it. So anyway, my hand is out there to the other creators that are following the Free Karen Read movement. Real quick, Babs Bunny, new member. Thank you so much. All right, let's keep playing. Yannetti, again, on fire.
Thank you.
Okay, thank you. Mr. Lally?
Yes, Your Honor. So in response to counsel's motion, just in response to the statement that every piece of evidence that's been provided thus far is inconsistent with the defendant's guilt and consistent with their innocence, I would have a large issue with that. But as it pertains to these particular pieces of evidence, counsel's right in that motions were filed. Counsel's right in that motions were allowed when, as related to inspection of said materials, and the Commonwealth has no issue with inspection of materials once they're back from the lab. Now, the last time we were before this court, back in February, the court had asked myself to reach out to the lab and see if there was anything that could be done to expedite the analysis. I did that, spoke with and filed the necessary paperwork with the lab to expedite as much of the analysis that could be done at that particular time. So at that time, what I was
Michelle, thank you for the 20
with
on
was a
PayPal. I
deadline
appreciate it.
of,
Thanks for the
no
support.
later than May 5th.
Thank you.
Those items, at least as far as the trace analysis and the criminalistics was concerned, would be
That's my
completed, and I
plan.
should expect something close to that date. I confirmed with the lab as of yesterday that that timeline is still a viable one. The case is currently in technical review, so once that's completed, then we should have reports that I'm able to provide to counsel. As it pertains to the inspection and the return of the items from the lab to the Commonwealth's, well, at least the District Attorney's Office or the State Police's custody, one of the issues that we've had with that is that in order to facilitate some of the necessary DNA testing, some of that testing would be exhaustive. And in particular, there is a hair sample that was recovered from the rear right quarter panel of the defendant's vehicle. It was taken to the lab, and I was informed by the lab that any testing of that for DNA for comparative purposes to Mr. O'Keefe would be exhaustive. So on March 10th, I sent counsel a exhaustive testing form that needed to be filled out, whether or not they want an expert present for that testing or don't want an expert.
Oh, this is what I wanted to say earlier, and I'm sorry to pause the video, but I like to pause the video because I like to talk. It's interesting that usually in cases, and I follow the Idaho 4 case, so if you know anything about that, if you're following that, know anything about it, the defense has been delaying everything, like literally delaying everything. And it's so funny that the opposite in this case, it's like the defense is like, let's go, let's get this on, let's go, we're ready. And I find it interesting that it's kind of reversed in this state, where the state is kind of lagging everything, dragging everything out. And in the Idaho case, it's the defense that keeps dragging everything out. So you find that interesting in these different cases.
For present for testing is really immaterial, but I need some sort of authorization from counsel before the sample is subsumed during the course of testing with the lab. I haven't heard anything back from counsel. I spoke to counsel numerous times. I sent emails, and I heard no response as far as that. So as far as the DNA testing is concerned, the delay on that is because I don't have anything back from counsel as far as whether or not they want an expert present, who that expert is, how to contact them, and how to facilitate the beginning steps of that particular testing. So that is why at least in no small part, why some of the items are still contained at the lab, is because the testing is still yet to be completed. But I do hope to have the trace and the criminalistics, and I expect that by next week at the latest. And again, whatever deadlines that the court sees fit to or deems fit to put on certain things, as far as that's concerned, is certainly within the court's prerogative. I don't think that we need deadlines. I don't think that we need an evidentiary hearing as it relates to it, but that's where it stands. As far as the video is concerned, the video was provided by the IT director for the town of Canton. There was a share file that was shared with the troopers. The troopers, upon receiving that, it was Trooper Dunn who received that video, not Trooper Proctor. If I could just speak briefly as it pertains to Trooper Proctor, there is no conflict. Trooper Proctor is not conflicted in this case. I indicated that specifically in some of the oppositions that were filed to Rule 17. So there's been some photograph taken from a social media site, which is purported to be Trooper Proctor with one of the McCabe's children who are a witness in the case. The child that's depicted in that particular photograph is not one of the McCabe's children. The McCabe's have 4 daughters. That's not one of them. It's a relative of Trooper Proctor. It has nothing to do with the McCabe's and nothing to do with this case. Whatever conflict counsel believes Trooper Proctor has just doesn't exist. Now, as far as the video was provided to Trooper Matthew Dunn of the CPAC unit with the District Attorney's Office. That was then shared with Ms. Crawford. It was a person in our office who specifically who deals with forensic and surveillance video and type evidence. It was then archived on our system. Recently, we reached out and spoke to the IT director with the town of Canton again. That share link I tried to send to council, email essentially wouldn't go through. We tried to open it, essentially it won't open. So the link expired within 30 days within 60 days, if not 30 days of it being shared with our office, but the exact information that was provided by the town of Canton was archived by Ms. Crawford, was then provided to council at her arraignment in Superior Court, as well as I was able to download it onto a Citrix file, which I then shared with council earlier this week. So what we have as a video, what exists as a video, what we were given as a video for those relevant time frames was placed onto the archived within our system, was then placed onto a disk, and what's on the disk and what's been provided to council is what we received.
Okay. All right, your next motion?
That would be Mr. Jackson.
Okay.
Liar. Liar. Liar.
Come on, man.
How dare you?
You are fake news.
Good afternoon, Your Honor. May it please the court. We are, as indicated in our papers, we are seeking summonses, and this is dealing with the animal control issue, that Rule 17 motion. We're seeking summonses directed at 2 entities, the Canton Animal Control and the Canton Town Clerk, both. We believe
I was muted again. I said, oh boy, Action Jackson. I love it, love it, love it, love it, love it. You're going to see a display here. You're going to see a display here. Get educated, everybody. This is it right here.
both have records. We know they both have records. These are records that we need, the defense needs, to shine a light on Karen Reed's innocence. These are records that are essential to our theory of the case. And these are records that we have no other option to get but through a summons. They've indicated to us they have the records, but they need a court order. They need some sort of a summons.
Give me a hell yeah.
Your Honor, in furtherance of this motion, I want to talk for a quick second about a couple of undisputed facts. Undisputed fact number one, on January 29th, 2022, Officer John O'Keefe was found dead in the yard of Brian Albert at his house at 34 Fairview in Canton. That is undisputed fact, where he was found dead and what the circumstances were surrounding that death are why we're here now. Second undisputed fact, when John O'Keefe was found, he had this set of wounds on his right arm. The medical examiner indicated that these wounds were concomitant with his death in terms of the temporal, the time that he died. These were wounds that he suffered at or near the time that he died. And the Commonwealth looks at these wounds and says, There's nothing to see here. Why are we looking at this? This is, you're following a red herring, basically. This is just a road rash. This means nothing. It has no impact on our case one way or the other. This is, according to the Commonwealth, simply a set of injuries that John O'Keefe suffered at the hands of being struck by a moving vehicle. Well, first, I would ask the common sense question, does this look like a road rash? I mean, the court's got years, decades of experience, life experience and legal experience. Of course, this doesn't look like a road rash. It's not a road rash that any of us have ever seen. Or does it look more like claw marks and bite marks from an animal, which is exactly what they are? Second, if it was a road rash, where's the rest of the road rash? John O'Keefe had one set of injuries like this. Deep scratches, deep puncture wounds on his arm, on his right arm only, from mid-biceps to mid-forearm and no other place. For instance, mid-biceps and mid-forearm that you might put in front of your face or your body if a large animal was attacking you, resulting in these wounds.
Just real quick, we're going to pause here for a second. Do me a favor, y'all. There's about 300 people in here. We only have 131 likes. That's not good enough. We can do better. Smash the like button. Every time you smash that like button and interact, this gets this stream out to more people that need to be educated about this case. So please take a second. The like button is free to smash. Smash that like button. Let's at least get 200 likes on this video before this video ends today, before this live stream ends today.
Why are the wounds confined just to his right arm? What about all the other pointy bits of a human body? If someone is rolled under a car or rolled in gravel because of the car, what about the shoulders? What about the knees? What about the ankles? What about the elbows? None of that exists. These are the only wounds. They're confined to his right arm, and they're deep scratch wounds, puncture wounds that are indicative of claw marks and bite marks from a large animal. And third, what about the Commonwealth's own expert? She has to have opined about this, correct? She has to have said during the grand jury, I mean, this was a full-throated investigation surrounding the potential murder of a police officer. What does the Commonwealth's own expert say? First of all, she was never asked by the Commonwealth during the course of the grand jury about the injuries. It took a grand juror actually asking the question of the witness, and she said, no, I cannot say that is a road rash. There's certainly not enough evidence to suggest that these wounds are consistent with a road rash. Well, she had to have at least talked about the fact that it was an animal, right? She had to. The Commonwealth had to have asked that question. She actually said nothing about whether or not that's consistent with an animal.
Hope it doesn't get there.
Because the Commonwealth very particularly did not ever pose that question. But we did. We hired one of the preeminent medical examiners in the country, a doctor by the name of Sheridan, Frank Sheridan, and he wasn't some deputy medical examiner. Dr. Frank Sheridan was the medical examiner for San Bernardino County in California, with more than 12,000 autopsies under his belt, the supervising medical examiner for one of the largest counties in California, and he concluded to a scientific certainty that these wounds are from an animal attack. Period. Full stop. So, what do we know about animals and the Alberts?
I love people that just come prepared, because I'm a prepper. You know, when I do shows, I prep extensively, and I have a systematic way of how I like the program to flow, because I want to give the best presentation to my audience. I want to be able to make sure that everything is clear and concise and understandable when you come to my streams. I don't really just turn the camera on and wing it, you know, and if you've ever been here, when I do presentational streams where I have things like this put together, you know, this takes hours of work to put into this. You know, I enjoy doing this stuff. I enjoy putting presentations like they're doing right now together to prove, to show. This is what you got to be looking at here. You know, I admire teams that just become ready, prepared, big visuals, get it out there so everybody can see it. I love it. Awesome stuff.
Exactly where Officer John O'Keefe was found
Big,
dead.
bold. Look at that. Bang.
In February of 2017,
Bang, bang.
we know that the Alberts had a dog. There's a photograph of Brian Albert with a dog, Chloe, in the foreground. By 2019, the Albert family had registered ownership of that German Shepherd. Moving on to 2022, in January of 2022, specifically January 29th, John O'Keefe suffers these animal puncture wounds, these animal scratches, these animal bite marks that are heretofore and up to this date, today, completely unexplained by the Commonwealth. By May of 2022, Karen Reed's defense team starts asking questions about this animal, about these injuries, about the dog, about what dog existed at the Alberts house. Where is the dog? We started inquiring pretty significantly. That same month, amazingly, the Alberts informed the Canton Animal Control that the dog was remarkably and mysteriously rehomed. The dog was gotten rid of. And to date, the Commonwealth has yet, as my colleague just mentioned, has yet to release the tissue samples to us for DNA testing to determine if there's evidence in these wounds
Thank you, Paula.
of a
Appreciate
canine
you.
attack, which we believe there
Thank
will
you
be.
for everything you do. I appreciate it.
During that grand jury testimony, Brian Albert admitted to three things. Number one, he admitted that he owned a large German Shepherd.
So if anybody's new in the chat and they're going, what is everybody talking about Chloe? Chloe is the dog that they're talking about right now. Just to give some context, you're probably seeing a lot of chat in here about Chloe. That is the dog that they are talking about right now.
Words not mine. A large German Shepherd. Number two, he admitted that the dog was at his home
Exactly.
on the
Dave.
night John O'Keefe, early morning hours, John O'Keefe was killed on January 29th, 2022. And the dog, according to his own testimony, was inside the house and never in the front yard, which is where John O'Keefe's body was ultimately found. And the third thing that he admitted was that the dog was, quote, not great with strangers, end quote. That's a dog owner's euphemism for the dog bites, the dog attacks, the dog is mean or can be mean. So why wouldn't the Commonwealth ask about these injuries? Why wouldn't the Commonwealth inquire, as we have been inquiring, about the nature of these injuries and their significance in terms of John O'Keefe's death? It's because they know that the answer completely obliterates their case. Their theory of homicide would fold if they got the true answers to these questions. The answer exculpates Karen Reed, and the answer inculpates Brian Albert. That's because if that dog was inside the house that night, not on the front lawn, not in the front yard, but inside the house, and these injuries were suffered or sustained at the time John O'Keefe was killed, then that means John O'Keefe was inside the house when he was killed. And it also means
Thanks, Dave.
that his body was
Appreciate
moved.
you. Thank you.
That's consistent with the facts that we also know to be true, which is not one person that was in that house and ultimately exited that house from that party that night, not one, saw John O'Keefe's body laying in the cold in the front yard. And that's because he wasn't there yet. Multiple people walked out of the house, multiple people who would have no other reason, who would have no reason to lie about that. A 200-pound man, 6'2", lying in the front yard on a light dusting of snow in dark clothing. Not one person saw him. But if John O'Keefe was beaten unconscious in, for instance, the basement of that house, and later moved to the front yard after the guests had left, there's your answer as to why no one saw him. And it also answers two other questions which are looming in this case. Why would Brian Albert rip out the floor of his basement months after John O'Keefe was killed? The second question, Why would he sell his house? So in the months following John O'Keefe's death, the dog has been gotten rid of, got rid of the evidence in the basement, got rid of the house, the crime scene itself. Your Honor, I would submit to the court that evidence is literally being destroyed right under our nose. It's been reported that the federal authorities have now gotten involved in the circumstances surrounding this case and have impaneled a federal grand jury to investigate some of these circumstances. But Karen Reed should not have to wait for the feds to figure out which heads should roll. I would implore the court, now is the time for the court to take some action and give us the tools, the defense the tools that we need to fully investigate this case. We need these records to track down this German Shepherd, if it's still alive, which clearly is an open question. Our understanding is, at least up to this point, is that the dog was not only rehomed, but rehomed out of state, out of the jurisdiction of this court and out of the reach of the defense, or at least that was the attempt. We need those records to find where that dog is. If the dog still exists, we need a saliva sample, we need a hair sample, we need something, and then we need the Commonwealth to give us the tissue samples that were taken at the time so that they can be compared. This is vital to the defense. We ask that the summonses at issue for the two entities that we've described, those summonses issue, our request clearly meets the Lampron standards. Number one, it's relevant evidence. Number two, we definitely need a subpoena or a summons. They will not provide the information without a court order. Number three, this information is necessary for our defense. And number four, contrary to what the Commonwealth constantly says, oh, well, this is just fishing, I think we've established this is not just fishing. We got a fish on the hook. We just need the court to help us reel it in.
Welcome in, everybody. Welcome into this Sunday edition show. A little earlier stream for me. I usually stream at 8:15 p.m. Eastern Standard Time, just about every night. We had an early Sunday edition here. I do have a very personal stream that I'll be doing tonight at 8:15 p.m. Eastern Standard Time, getting some updates on Chelsea Grimm's case, a case that's very near and dear to my heart. And then later on at about 11 o'clock, I'll come back and just kind of hang out, watch the ball drop. Nothing crazy. I don't go out. It's not my thing. I'll be home in the safety of my home, hanging out with hopefully some of you. If not, no big deal. I hope everybody goes out and has an amazing night. Be safe in what you do. If you're out drinking, please don't drive. Drive home sober. And if you are drinking, let's get a friend or a ride share to pick you up, get you home safe, and do your thing. Do your thing. All right, let's continue here. The May 3rd hearing of Karen Reed's case. I believe this is the most important hearing to date, and we are all very excited to see the new hearing on Friday, what new details will be unfolded, and the tone of that hearing. All right, let's keep playing through here. Jackson up, speaking live in court right now.
I will submit on further oral argument regarding the issues or the summonses surrounding the animal control and Canton Town Clerk. If the court has any further questions about those, I'm happy to answer them. If not, I can certainly give the court a preview of the second Rule 17 motion, which deals with the phone records and the actual phone of Brian Albert. But I believe the court has indicated, and we've suggested, that an evidentiary hearing is in order.
As I understand it, the parties have agreed for an evidentiary hearing, and we rearranged our schedule a bit so that we could accommodate you.
That's perfect.
Okay.
The only thing I would say in furtherance of that, very briefly, is the Commonwealth has suggested that Rule 17 is just sort of a regurgitation of something that we filed back in, I think it was September, that could not be further from the truth. There is new information. There's dozens of pieces of new information that we have.
What I'm going to do because of that, let's let Mr. Lally respond to your remarks on the
Oh boy, here we go.
First.
Thank you. Your Honor, first I would state it's an interesting sort of straw man argument as far as it being road rash, or that the Commonwealth has always maintained that it's road rash on his arm. No one has ever said that but counsel for the defendant. As far as the injuries are concerned to Mr. O'Keefe's right arm and right forearm, they've always and consistently been described as abrasions caused by blunt force trauma, not road rash. I'm not really sure where the road rash comes from. What I would submit in conjunction with that is, again, divorcing whatever evidence the defendant claims from the context of the rest of the evidence and the rest of the case. It's a little peculiar and conspicuously clear from the defendant's fact section that the damages to the right rear corner panel of the defendant's vehicle, embedded within the bumper to that vehicle, is pieces of a cocktail glass. The victim, Mr. O'Keefe, is last observed on surveillance video, external surveillance video from the Waterfall establishment that he left just prior to going to 34 Fairview, with a cocktail glass in his right hand. Same arm that's injured, the same type of glass that is then recovered from the bumper.
This theory, I just... This theory is so wild and out there that it's impossible. I'm telling you, it's the Dave Chappelle effect. It's the Dave Chappelle defense. Just sprinkle some crack on it. You know, just sprinkle around some tail light. Just sprinkle around some cocktail glass. It's so out there. I mean, how can people listen to this and think, oh yeah, it's yeah, that's the, yep. Oh, yep, definitely. I mean, I'm sorry. Let's just take the fact of someone listening to this hearing for the first time, okay? And we don't know what side the prosecution or the defense is on, okay? And you took a vote. Are you going to believe those two guys over there or this guy that's standing up right now? You know what I mean? It's unbelievable. I'm telling you, it's Dave Chappelle. Just sprinkle some crack on it. If you don't know what that is, look it up. It's a hilarious skit that he does. Just sprinkle some crack on it. It'll be okay. I mean, it's so out there.
Defendant's call.
It's almost embarrassing.
As the court is well aware, and I just stated for the record, under Rule 17, the defendant has the burden, or the moving party has the burden to establish that the documents are evidentiary and relevant. Secondly, that they are not otherwise procurable reasonably in advance of trial. Thirdly, that the party cannot properly prepare for trial without such production and inspection. And fourthly, that the application is made in good faith and is not intended as a general fishing expedition. The issue that the Commonwealth takes with the defendant's request as it applies to these particular records is with number 1 and number 4. The Commonwealth would submit that the showing from the defendant is simply insufficient to establish any relevancy or evidentiary value to these records.
Yeah. And
then secondly, that this is the very epitome of a fishing expedition. The indication, even from the verbiage that's used by counsel in the motion, sort of sheds light as far as as I just stated, the sort of epitome of a fishing expedition. It's language such as it could shed light, or if true, this fact would undermine the prosecution's entire theory of the case. There have been a couple of theories that are stated within the context of counsel's motion. I can state for the record, those are not the Commonwealth's theories. No one ever said that the vehicle struck Mr. O'Keefe in the head, and that's what.
Yeah, and then the other thing too, listen, I don't like to pick on people's appearance and stuff like that, but what was the street scroll says, dude, your hair, it's time to shave it off, bro. Yeah, listen, for guys that are out there, okay, if you're balding, okay, it's okay. Just shave your head. You're gonna look a lot better than when you're trying to hang on to this shit, and it's like the circle back here or the widow's peak. Just shave your head, bro. It doesn't matter. Shave your head, grow some balls, grow a beard. You know what I mean? Get some scruff on your face. You're fine. You're going to be fine. Chicks are going to like you for who you are. It doesn't matter about your hair. And if they're going to be shallow about someone's fucking hair, then fuck them. You don't want to be with them anyway. You know what I mean? Grab a cap, throw a cap on. Who cares? But I love all those people too. You only wear a cap because you're bald. No, I wear a cap because I basically came out of my mom's womb with a cap on. I've been wearing a cap since day one. So, Just shave your head, bro.
Cause the injuries. That's actually not at all what the grand jury testimony or the evidence has
I
shown
don't give a
throughout
fuck
the
about
course
hair
of this
anymore. It's easier
investigation,
doing
throughout the
this.
course of this case. But those could, and if true, those very words by definition evince the very nature
What do
of
they say? And every year when they have the top list of like all the, and I don't really care. I'm just saying though, all the top list of all the sexy guys in Hollywood. What do they all have in common? Most all those guys are bald.
this particular request. The first issue would be with the time frame, as it's stated within the motion. It's from 2015 to present. I'm not sure why so expansive a time frame is needed or necessary or relevant to anything that is a subject matter before the court. As counsel suggests, that photographs of Mr. O'Keefe's injuries suggest that he was severely beaten and left for dead, having sustained blunt force injuries to both sides of his face as well as to the back of his head. That there's evidence of defensive wounds. There's a cluster of deep scratches and puncture wounds to his upper arm and forearm. And then the defendant essentially asked the court to take that inferential leap that these injuries, which are wholly inconsistent with the injuries noted by both the emergency medical personnel at Good Samaritan, when Mr. O'Keefe was taken immediately from the scene where his body was discovered, and from the medical examiner's finding and sworn testimony.
It's true.
So wholly
That is
inconsistent
true,
with those,
Timmy.
that these are
That is
then
true.
take the inferential leap that these are consistent with bite marks or scratch marks from an animal,
Exactly,
specifically a
buddy.
dog.
Who gives a shit?
In support of these assertions, as counsel
That's fine.
stated, there's an affidavit from Dr. Frank Sheridan that the injuries are consistent with animal claw or scratch mark.
Uh-oh, what happened here? Oh, this was the bunk in the. That's not me. That's the live. I think their feed probably. We'll get it back up here in a second.
Detail what those injuries are. In those medical records, what the personnel at Good Samaritan, the doctors, the nurses who examined Mr. O'Keefe when he came into their facility, describe his injuries as a right superior orbital ridge region, approximately 7 millimeter laceration, positive for surrounding soft tissue, swelling, and positive breath sounds bilaterally, pulseless, positive superficial abrasions to the right forearm. Dr. Scortibello, the medical examiner in this case, who testified at length before the grand jury, described Mr. O'Keefe's right arm injuries as scratches caused by a blunt object. She described or noted that they appeared to be in a linear pattern. She detailed that she observed no signs of an altercation or fight from her thorough internal and external examination of Mr. O'Keefe. And lastly, she testified in great detail as to the swelling of his eyes being related to the fractures in his skull and how those manifested into the observable swelling and discoloration of his face. And essentially what she testified to was that there was a laceration on the right back of Mr. O'Keefe's head, that there was a skull fracture in that immediate area, the right parietal area of the victim's skull. That then caused a swelling on the brain, which she observed, as well as Dr. Stonebridge observed during her neuropathology examination of Mr. O'Keefe's brain post-mortem. That then caused the swelling underneath of the skull, caused the radiating skull fractures that she observed in Mr. O'Keefe's skull throughout, and that the essentially nowhere else for the blood to go, and the looseness of the vascular tissue behind the eye then causes both of the eyes to swell. There's no evidence.
And it sounds like a punch to me. I don't know.
That Mr. O'Keefe was beaten and left for dead. There was no evidence of any defensive wounds. She was specifically asked those questions and testified to that before the grand jury as to those injuries and how they sustained. There's absolutely no evidence that Mr. O'Keefe ever entered the residence at Fairview on that particular evening. Counsel mischaracterizes some other statements made by a witness, Mr. Brian Nagel, who had come to pick up his sister at the residence. She came out, he observed that vehicle. He observes that vehicle from the entirety of the time that he's there. So he's pulling on to Fairview. Ms. Reed is coming on to Fairview in the opposite direction. The right blinker on and a left blinker on. The operator of the vehicle that Mr. Nagel is in then essentially flashes his lights and allows Ms. Reed to pull in first. So Mr. Nagel is there the entire time that Ms. Reed pulls onto the street when she pulls up. Indicates that she initially pulls over to the right-hand side of the curb, then pulls the vehicle forward a little bit further. That's corroborated in testimony from a number of different people who were inside the house, as well as Mr. Nagel's sister, who then came out of the house and talked to her brother at the door of the truck that he was riding. Mr. Nagel further indicated that at no point did the brake lights come
Oh,
off,
wait.
including the center top
Is this
light.
the Olivia that I recently have just found out that you're supposed to be Karen Reed? I've been hearing about that. So forgive me. Again, I'm getting tuned in with all of this new stuff that you all have known about for months. Aren't you the Olivia that's supposed to be Karen Reed?
The SUV that he observed in front of the house. There were no footprints outside of the vehicle. He never saw anyone exit the vehicle. No one in the house reported ever having anyone come inside the house or seeing anyone exit the vehicle. And I'm a little confused just as far as counsel's statements, as far as the multiple people saw Mr. O'Keefe. Never saw Mr. O'Keefe come into the house. Or if he comes into the house and he's attacked by the dog, I'm just a little confused as far as are they in the conspiracy, or are these people sort of let out of the conspiracy because they say something that doesn't further that conspiracy? If they're all in the house and Mr. O'Keefe comes in the house and gets attacked by a dog and then gets dragged out to the bottom of the lawn and left there for dead, then why do they all testify that no one came into the house? It's consistent throughout the entirety of all the witnesses. It's consistent with Mr. Nagel as well. It's consistent with the forensic evidence. It's consistent with every piece of evidence that has come to light at this point. And there's further statements in regard to the dog. Some reported incidents several months after the death of Mr. O'Keefe. The counsel suggests ineluctably that the animal was violent and prone to violence from one incident that postdates this particular time frame of Mr. O'Keefe's death, and seems to punctuate that this circumspection on and on about how violent the dog is from an incident that he has no information about, whether or not it involved another animal.
I got 3 down votes. Maybe that's the 3 people. Oh, good stuff, man. I love it.
Whether or not it involved another human, whether or not it involves what exactly the incident occurred. This is simply not what Rule 17 is to be used for. That's what the case law has consistently held, is that it is not a discovery tool. It is based on information, relevant evidentiary support, which is completely and utterly lacking in this particular motion, in this particular submission. So for those reasons, the Commonwealth would request that the motion be denied.
So the second Rule 17 motion, are we going forward on that and then having the hearing regarding the timing of the video? How are we going forward with this before I hear from you on the substance, Mr. Jackson?
Well, of course.
What is the next date for?
May 25th.
Right. What's it for? The evidentiary hearing?
Yes.
All right. So do you plan on arguing your Rule 17 motion today or that day? Not both?
That day.
Okay.
I'd rather reserve and
that makes sense that makes sense to me as well. So we're finished for today, unless there was any follow-up to Mr. Lally. I'm not going to hear a preview on the motion that we're going to hear on that day.
That's fine. I do have some points to make.
Okay, I'll hear you on that.
Thank you. With regard to the dog, first of all, I think the Commonwealth misses the point. If there was a fight inside the house with the dog's owner, the dog would likely attack. That is the idea that is borne out by the evidence that we have. We know that he was beaten. We've got evidence that John O'Keefe was beaten, that he lay there unconscious. And we also have evidence that at the time he was beaten facially and blunt force was used against the back of his head, he was also attacked by an animal. Well, Brian Albert, who's a known fighter, owns a 90-pound German Shepherd that has since been gotten rid of and had a skin-piercing incident as the excuse for having gotten rid of it. So we know that the dog attacks.
Gab, thanks for the 10
to
on the cash app. I appreciate it. Thank you.
evidence.
Thanks for the support.
We weren't saying, we don't suggest that the dog killed John O'Keefe. We're suggesting that the dog was there when John O'Keefe died and also attacked John O'Keefe. That's the point. This is the first I've heard of the Commonwealth's new position after, 15, 16 months, that somehow John O'Keefe was stabbed or cut up with a broken cocktail glass, which would produce these injuries. That makes absolutely no sense.
Dude, that is so good right there. I got to rewind that. We got to hear that again. That is like the boom moment. Jackson at his finest.
Was there when John O'Keefe died and also attacked John O'Keefe. That's the point. This is the first I've heard of the Commonwealth's new position after, 15, 16 months, that somehow John O'Keefe was stabbed or cut up with a broken cocktail glass, which would produce these injuries. That makes absolutely no sense. It just doesn't pass the sniff test. These are not from a cocktail glass. Who did that to him? Is there new theory that Karen Reed got out of the car, broke a cocktail glass, then wielded an edge of that cocktail glass and cut up John's arm? Then John stood there while she jumps in the car, slams it into reverse, then hits him with the car, with her taillight in the back of the head. It makes absolutely no sense. That is the Commonwealth grasping at straws. If it walks like a duck and talks like a duck, it's a duck. This looks like an animal attack because it is an animal attack. And it's
Aiden,
at the same time,
yes. You see that? Aiden shakes his head yes. I mean, come on. Like, this is what I have to... I'm just trying to get people here. Like, you got... If I didn't tell you the prosecution and the defense was, and we just had all these presentations in the courtroom, I mean, what are you going to believe? I just don't see it. I don't see the state's argument in this case. I'm serious. It's a lot of reasonable doubt, man.
It makes absolutely no sense. That is the Commonwealth grasping at straws. If it walks like a duck and talks like a duck, it's a duck. This looks like an animal attack because it is an animal attack. And it's at the same time, temporarily at the same time, that he was otherwise beaten and then ultimately left for dead. Interestingly, it's interesting that the Commonwealth doesn't mention the basement in their arguments. I mentioned the basement because that's very likely exactly where John O'Keefe went once he walked into the house. There's no evidence that John O'Keefe walked into the house. The Commonwealth has evidence that John O'Keefe went into the house. They haven't. They just sat on it for several years, or for several months, over a year. That the Apple Health data from John O'Keefe's own phone
Love how he gets this in there.
establishes that once he was at the location at 34 Fairview, he climbed 3 sets of stairs. The Albert House happens to be 3 floors, a basement, a middle floor, and an upstairs. His Apple Health data also shows that he took multiple steps after he left the car, after he left Karen Reed's vehicle. The multiple steps indicate that he was in the house. If, in fact, the Commonwealth were correct, and he stepped out of the car, was hit by the car, and fell down and died, if that's what their theory is, he would have no Apple Health data suggesting that he was climbing stairs and walking about as if he were inside the house and was ushered down to the basement, at which point there was a fight, he was beaten to unconsciousness, and then everybody in the house leaves, not having to go down to the basement. There's a door that services that basement that's closed. So there's no reason for people who are upstairs, either upstairs or on the main floor of the house, to even know that there had been a fight downstairs, or that John O'Keefe never made it out of the house alive or conscious. With regard to Ryan Nagel, the Commonwealth leaves out probably the most important part of his testimony.
You know what I really like about Jackson is that he takes a very complicated situation and makes it very easy for people to understand. the way that he navigates through his storytelling and his presenting of the evidence and the facts. I just love the way he flows like that. And that's a real skill. I mean, that takes a long time studying law, being in courtrooms and practicing your craft, and just, you know, being a great lawyer that just can present facts the way he does. And it's very easy to listen to. It's almost what are the words I'm looking for? You know, it's almost an honor to listen to, because there are so many horrible attorneys out there, and they just bounce so well off each other. And I don't want to leave Yannetti out of this, because Yannetti is just great in his own mind as well too. But Jackson, to me, just really captivates the way that he flows his storytelling and case telling. It's amazing stuff. I wish I had the said discipline to get through law school. I tried pre-law a long time ago, and I just didn't have the discipline to do it. And if I did make it, this is who I would want to be. You know, this is who I would want to be, a lawyer like this. Just really good stuff.
Ryan Nagel's
And
testimony.
let's not forget Bradel. I mean, Bradel's amazing too. Turtleboy's lawyer. I mean, these are all great lawyers. Really, really good lawyers.
Is that he arrived just after Karen Reed arrived. They arrived not at the exact same time. She turned down the road. Then he turned down the road. As he approached the road, as he approached.
Danielle, thank you so much for the $4.99. I appreciate your support, and thank you for being a moderator here. You're always here. You're always in huge support of LTL. I really do appreciate it. All my moderators, you do such a great job in supporting what we do here and trying to grow this channel. And I think 2024 for LTL is going to be an amazing year. It's going to be a huge year. I am clawing in teething my way to 15,000 subs. That's kind of my landmark right now, my landmark goal. I'm hoping to do that in the next couple of months, and then it will be on the 20, 25,000. And I want to get to that 100,000 play button someday. I think, you know, it's doable. But it's people like you that make this channel and make this community go. You know, the people that come in and really care about these cases and support this case. And we have a long way to go, and we have a lot to still talk about in this case. And then after this case, after Karen Reed is exonerated of all this and walks away, we're still going to have tons of things to talk about. And I believe that this case is going to change many, 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 many things in our justice system, the way that this case is looked at. And another case that's going to change is the Idaho 4 case. That is going to completely change the way that we look at our justice system. So let's hope for justice for both of these victims in this case. It's very, very important in these cases. All right, let's keep playing here. Thank you.
The house, he then pulls to a stop. He had her car
Awesome. Thanks,
in his
Jimmy.
sights
Thanks for being
the
here. I
entire
appreciate
time,
it.
just after she had already arrived. Certainly time enough for John to get out of the car and walk toward the front door. He said that he observed that there was no taillight damage whatsoever. He later observed inside, either through a dome light or through other ambient light, that he was inside the passenger compartment of her car, and that she sat there alone. And most important, he didn't see her hit anybody with her SUV. That's the most important part of Ryan Nagel's testimony. He didn't see her hit John with the car, which he would have had to have seen if he was situated right behind her. And the Commonwealth has repeated what they've oft repeated several times, which is there was no sign at all of any kind of an altercation or fight. Well,
I love it.
If there's no sign of an altercation or fight, how can you turn around and say that a cocktail glass did this? They can't talk out of both sides of their mouth. How could they reasonably ignore two black eyes, a laceration over his right eye,
Paula,
a
thank you for the
laceration at
gifting.
his
Thank you.
nose? He looked like he had gone 10 rounds with Mike Tyson, as my colleague has once analogized. Of course there's evidence that he was in a fight. The back of his hands, deeply bruised. Those are called defensive wounds. I don't care what their medical examiner called it. Anybody who's seen any sort of a fight, a street fight,
5 new members.
knows that the back of the
Welcome
hands,
in.
the back of the arms get the brunt of the punches as you cover your face. Of course there were signs of a fight. Not just a fight, a brutal fight. And what does a dog do when its owner is in a fight? What does a German Shepherd
Welcome
do
into the
when
membership
its
group.
owner is in a fight?
Those are free memberships. They're $4.99. Okay, you're gonna get 1 month free to get all the members only content, all members only lives. You can go down and watch all the members only content. Gives you exclusive access. All I ask is this: at the end of that membership in 30 days, please just do me a favor, sign back up. You don't have to hit the $4.99 option. I have an option for $1.99 that keeps supporting this channel and keeps moving this cause forward. All right, let's get back to the hearing.
Reaches out and attacks and supports his owner. And what does a person do when a dog attacks? Usually puts his arm up, his dominant arm up, to protect himself. And that's where the lacerations, the bite marks, the claw marks appear on John O'Keefe's arm. This is not a fishing expedition. The Commonwealth has an unreasonable expectation. They cite to words that we use what the evidence might show, or what it could show, what it potentially will show, as a weapon to say, well, see, they don't know what the records are going to show. Well, if I knew what the records are going to show, I already have the records. I wouldn't need the court to ask for them. Of course, I don't know everything that's in the records. And the reason that we asked, Your Honor, for 2015 is because we have evidence that in 2017, the dog looked full grown. So we wanted to go back and bracket the proper amount of time. If say the dog was a couple of years old at the time that photograph was taken in 2017.
Thank you, Stacey.
We want all the records associated with that dog, which means we bracketed our request. It's not overly burdensome. It's certainly not burdensome to the Canton Animal Control, and it's not burdensome to the Canton Town Clerk. And if the records don't exist because they just don't, they're too old, then no harm, no foul. But that's why we bracketed our request to go back from 2015 to present. And with that, Your Honor, I believe that we have made a good faith showing. We have met the standards of Lampron, all 4 standards of Lampron, and the summonses should issue. And also.
All right. Anything else, Mr. Lally?
Just briefly, Your Honor, as it pertains to Commonwealth would agree that attributing the cuts on Mr. O'Keefe's arm in their entirety to a cocktail blast would be somewhat ridiculous. That's not what I said. And that's not what I was attributing them to. I think the court understood that, but just so counsel understands that as well. As it pertains to Mr. Nagel, what is in his testimony is that he had the vehicle. They arrived at the residence in tandem. The vehicle was there when Mr. Nagel left. So while he sees no one exit the vehicle, no one enter the house, and no one else sees anyone exit the vehicle or enter the house during that specific time frame, the defendant, and presumably Mr. O'Keefe, are still there and still in the vehicle at the time Mr. Nagel leaves the house. That was the point that I was making with that. As it pertains to the Apple Health data, and obviously we'll get into this a little bit more when it comes to that subsequent Rule 17 motion, the Apple Health data is the same Apple Health data that's being relied upon for the supposition that Mr. O'Keefe went inside the house. That same Apple Health data has, among other things, Mr. O'Keefe taking 46 steps and traveling a certain bit of distance around 11:56 a.m. on January 29th. The problem with that is that he was pronounced deceased at the Good Samaritan Medical Center at 7:50 a.m., some 4 hours prior to that. In addition to that, from the information as far as when that ascending or descending of stairs occurred between, I believe it's 12:21 and 12:24 a.m., there's a Waze search and location data for Mr. O'Keefe's phone. The Waze search is conducted, and the GPS location information from Mr. O'Keefe's phone shows him en route to the house and not arriving at the house until 12:24 a.m. So the information the counsel is relying on has him going up and down 3 flights of stairs before he's even at the house. So for those reasons, again, the Commonwealth would submit the defendant's not met its burden and ask that the motion be denied. Before we do conclude, I just did want to remind the court there are a couple of other issues that I need to address with the court, specifically the Commonwealth's motions to impound and the Commonwealth's motion for access to the defendant's phone.
Okay, I'll hear you.
So there were 2 motions to impound that the Commonwealth had filed. One pertains to the grand jury transcripts and exhibits that I had attached as attachments or exhibits to the opposition to this specific motion, really to
Okay,
both motions.
and those are impounded by statute.
Right. The other motion to impound that I filed pertains to the attachments to the defendant's Rule 17 motion pertaining to Mr. Albert's cell phone and the call detail records of Ms. McCabe and Mr. Albert. Now, certainly, the Commonwealth is not saying in any way, shape, or form that those items shouldn't be submitted. The defendant can submit whatever she wants, whatever counsel wants in support of that request for the court to review. But the manner in which the information is released, and specifically what I take issue with, and I'd be remiss if I didn't say this on behalf of the O'Keefe family.
I'm not sure they hear you.
In reference to the motion to impound the attachments to the defendant's Rule 17 motion for Mr. Albert's phone and the call detail records of Mr. Albert and Ms. McCabe. I'd be remiss if I didn't, on behalf of the O'Keefe family, as well as just what the statutory rules are, and specifically I'm talking about the Supreme Judicial Court, Rule 124, pertaining to protection of personal identifying information and publicly accessible court documents, which I would imagine that at least Mr. Unetti, even if Mr. Jackson and Ms. Little aren't familiar with, does provide rules as to how things are filed that are of that kind of sensitive nature and that kind of biographical information. And they're routinely filed with the court with a motion to impound or a motion to seal and not filed directly with the media. The issue being that there are photographs depicting Mr. O'Keefe's postmortem at the Good Samaritan Medical Center, as well as possibly some autopsy photos that should have been impounded. There are unredacted Canton Police Department reports, multiple copies. Again, not
Dave.
anything that Commonwealth takes any issue with the court reviewing, but as far as them being made public with those witnesses' names, dates of birth, social security information, addresses, phone numbers, things of the like that should be impounded pursuant to the statute as well. And in particular, I do take issue with that motion, specifically on page 11. There is a specific reference made to the name of the decedent's niece, which is strictly prohibited as far as being provided in a public document. So for those reasons, I would ask that the attachments to that motion, to whatever extent it can be at this point, given the public release of them, be impounded.
Mr. Unetti?
Your Honor, I believe that some of that information may be in the public domain already, so it may be that the cat is out of the bag with regard to some of it.
It is now, right?
I'm sorry?
It is, the cat's out of the bag now.
Right, yes. So, I mean, we're agnostic on this motion to impound. We have access to it. The Commonwealth has access to it.
Yeah, if you're talking about framed, we've played that. And thank you, Joseph. Says new sub here, not to take away from your channel, but those new to the case should go watch Turtleboy's video starting back on April 2023. You go down the rabbit hole. I think that you're talking about framed. We've played that. Yeah, we've played that several times on the channel. But thank you for pointing that out. Of course, my last stream, we did kind of a mainstream media brush up on what they were saying had happened, and then we played framed, which is on Turtleboy's channel. But thank you. Yep, yeah, played it the other night. All right, let's keep playing through here. We're gonna get through this, and then I want to talk about the federal probe.
The court has access to it.
All right, so by statute, everything that was raised by the Commonwealth was supposed to have been requested to be impounded at the time it was filed. So that was not done.
Are you talking about the motion that we filed with regard to the Albert phone motion?
Yes, the attachments. Mr. Lally just outlined it.
I don't think that there were any grand jury minutes attached to that motion.
No, that was a separate motion that Mr. Lally just filed on behalf of his motion.
Right, and we don't have
when he was taking issue with the defendant had filed.
Right. Okay. Yeah. Again, we don't have an objection at this point.
All right, Mr. Clerk, those are both allowed. All right, is the hearing? Those are both allowed by statute. So, is this hearing over?
Your Honor, if I could just address, the Commonwealth had filed some time ago a proposed procedure regarding communications stored in the defendant's iPhone. So we had addressed this briefly, I think, on the last court hearing date in February in relation to the defendant's phone. So the defendant's phone was seized lawfully from her pursuant to a search warrant. The information contained therein was then downloaded. Upon a cursory review of that information, there was an indication that there was some communication between Ms. Reed and Mr. Unetti contained within the information within that phone. So obviously all examination of Ms. Reed's phone from the Commonwealth's perspective ceased at that time. and we had begun exploring and filing this motion. I had it in hand to file with the court on the last date. However, after several discussions with Mr. Yannetti and counsel for the defendant, I was then informed in court on the last date that the AFE, or the independent sort of forensic examiner that would look at that phone, was believed to have some sort of conflict. It was not acceptable to Mr. Yannetti. So there was a separate person who essentially runs the lab at the Attorney General's office, who I spoke to Mr. Yannetti about whether or not that person would be acceptable. He does have a conflict, just so the court is aware, as far as grew up in the same town as the victim and his siblings. But Mr. Yannetti indicated that he, at least verbally to me on that date, that he didn't see any issue with that conflict, as the person would just be assigning it to a couple different forensic examiners within his office. I then modified the motion to incorporate that subsequent AFE, sent a copy of the motion to counsel 6 weeks ago or so, and still have received no response. So what I'm looking for today is action on that. The other thing that I would note for the court is that counsel had asked for a raw extraction copy of the material from the defendant's phone, which was then provided to counsel on March 22nd. So for over a month, the defendant has had access to the defendant's phone, and the Commonwealth has not, because counsel has failed to respond to whether or not the AFE was reliable or not. And what I was referencing on the last court date is the court had indicated that if we were to come to some sort of agreement, the court could act on the papers and obviate the need to address it on this date. It hasn't happened. I would submit that the proposed protocol was more than reasonable, and I would ask that it be allowed by the court.
So, Mr. Yannetti?
Yes. I was the one to suggest that it be analyzed by the Attorney General's Office, Cyber Crimes Division. I thought that was clearly, we have no objection to that, but I'll announce it in open court. We have no objection to that. The motion for the protocol, procedure is agreed to.
And you're okay with the individual that was cited in it?
Yes, the individual who was cited in it is the head of that unit. I know who he is. I respect him. He revealed to me at the start that he has a personal conflict. I have no issue with him assigning it to somebody in his office.
Okay. So the motion's allowed by agreement?
That's fine.
Okay.
Thank you.
Clerk? Yes. Motion's allowed by agreement.
Just one other thing. Mr. Lally had mentioned to me, and I don't know if he still intends to be heard on this, but there was an issue of exhaustive testing that I thought.
He argued that a while ago.
Okay, and was that acted upon by the court?
He said he was waiting to hear back from you where we stood on that.
Right, so with regard to that, Judge, we're all for exhaustive testing as long as we can have our expert present at the time.
So Mr. Lally, would you explain to it? Would you say again what you explained to me?
Certainly, Your Honor. So there's a form that's provided by the lab that I then provide to counsel. In this case, in any case, that where exhaustive testing is necessary and the sample would be subsumed within the analysis. So I provided that to counsel. I just simply need counsel to execute that form, indicate whether or not they want someone present and who that person is, what their contact information is, and then I'll provide it to the lab. The lab will then contact their expert and schedule a time for the testing to be done.
Okay, we're happy to do that, but my understanding from Mr. Lally's earlier argument is that only applies to the hair that was found on the car. That was not part of any motion that we had today in terms of a motion to compel. What about the other evidence with regard to the tissue samples and everything else that we actually asked for in our motions today?
Is there exhaustive testing on any of those items, Mr.
Not that
Lally?
I'm aware of.
Okay, fine. Yeah, so we'll sign regarding the hair. We're not concerned about that.
Okay, is that everything?
From the Commonwealth, yes.
I believe so, Judge. Thank you.
All right, thank you. We'll see you on the 25th.
5:25 at 9:30, correct? 9:30. Thank you.
That's it. Okay, let's talk about just what. Wait here another minute, and we're going to talk about the federal probe.
So I'll come back. Jimmy, just let me know. Just taking this for 1 minute.
All right. Let's go to the probe, and then we'll end this stream. I appreciate, again, everybody being here this afternoon on this Sunday. I'm not sure how the Pats are doing. I haven't looked. but they haven't been done well this year, and I appreciate everybody hanging out. We're going to talk a little bit about the federal probe through Vinnie Politan, obviously back in December, what date was it? The 23rd or the 22nd? Again, I get screwed up with dates, but it was sometime in late December. We had an announcement of a federal probe, and Morsi basically trying to find his way around that. 20-14. All right. Looks like they're down 20-14. That's not good. But anyway, we'll talk about this probe, get everybody educated that is new to this case to understand what is going on. I tell you to seek out all the information you can in this case. I have a couple of creators that I think you should follow. Tom CPU, The Glare, The Young Jerks, Making Law Simple. There's quite a few others out there, and I apologize if I miss you. And of course, you can come here to LTL True Crime. We will be carrying all of the Karen Reed case and just getting our focus back on that, and the movement, because that's the most important thing, to stay together, to keep this movement going, and that's it. So let's play through this from Vinnie Politan about the federal probe.
It's a case unlike any case I've ever covered. What is happening up there in Dedham, Massachusetts at the courthouse, in Canton, Massachusetts, where all this happened, the protest, the support for someone accused of murdering a Boston police officer, it's unreal. And every time I do this story, I get all these direct messages and notes, some of them a little heated, from both sides of this controversy. No one is happy, and that tells me that this is different than most of the murder trials that we cover here, and then I've been covering for years. And it all begins as a Boston police officer, John O'Keefe. He's dead. He's dead. The question is, how did this happen? Who is responsible? And obviously, as you heard, there are two completely different stories, versions, narratives of what happened the night that John O'Keefe was killed and then found dead in the snow. On the one hand, you have prosecutors saying that this was a crime of passion. These were two lovers who had an argument, and she was angry, and she struck him with her car and left him there in the cold to die in the snow. That it was about a relationship gone bad, and a woman who was angry, and that's why she did it. That's one version. That's what the prosecution has said. A lot of times you don't get another version, especially before a trial, but in this case you have. And the defense and Karen Reed are saying, no, it wasn't me. It was someone inside the house, and this was a police cover-up. It was a police party, and it was a investigation that was done by people connected to people in the house. And that's a problem. And it's a huge cover-up, and she's being framed for all of this. So there's a lot.
You all know what spawned Court TV, right? You know what spawned that essentially made Court TV, right? You know what event made that. Let's see if everybody's smart in the chat. Do you know what court trial made Court TV? I'm sure you all know. Yep. Exactly. That essentially spawned off the Court TV channel. Yep, the OJ case. Yep, 100%.
To get to every time we do this story, there's a lot of layers, there's a lot of evidence. But now there's a new report. Boston 25, one of the local stations up there, has been doing amazing work on this. Real big reveal that caught my attention, is catching a lot of people's attention. Take a look. 25 Investigates has learned that the Norfolk County District Attorney, Michael Morsi, sent a letter to the Department of Justice. Those are the feds, folks, okay? So you've got the local prosecutor sending a letter to the feds requesting that the federal probe of the Karen Reed case be transferred out of Massachusetts. The feds up there are looking at this investigation. Morrissey's letter provides the first official confirmation that the U.S. Attorney's Office for the District of Massachusetts is looking into the arrest and prosecution of Reed. So in the middle of trying to prosecute someone for murder, the feds are looking at...
You know what? I'm curious. Will Jackson and Yannetti bring this up in court on Friday? Huh. That'll be interesting to hear. I wonder if they'll get that out there on the record. What do y'all think? Do you think they will? You think they're going to put this out on the record on Friday?
People who investigated the case and investigated Karen Reed. This is highly unusual, but big, big news. Joining us tonight from Boston, Massachusetts, the investigative reporter at Boston 25 News, Ted Daniel, is with us. Ted, great to see you tonight. Unbelievable work and investigation you guys are doing. Before we get to all that, let me just take a step back. And your analysis of this story, this case, this trial, everything that's happening. I'm feeling down here in Atlanta that things are at a fevered temperature up there with everyone involved. What's your take?
Well, like you, I'm getting the same DMs and emails from people who are vested in this case. I've been doing this for 25 years. I've covered a lot of high-profile cases, including Aaron Hernandez, both of his trials, gavel to gavel. I've never seen anything as polarizing as this, where people are so absolutely dug in on each side. And that has led to just this firestorm that's existed since about April, when the defense came out swinging that they believe this is a cover-up.
So locally, how is this playing? Because now you guys have confirmed for the first time that there is, in fact, a federal investigation into the investigation of Karen Reed and the investigation of the death of John O'Keefe. Give us a little bit of the parameters of what this is about and what everyone is saying about that part of this case.
Yeah, we weren't the first ones to report the federal investigation. That had been out there, but we were the first ones to confirm it. And the way we did that was interesting. I got a tip that the Norfolk County District Attorney, who is the district attorney where Canton is, that he sent a letter to the Department of Justice essentially pushing back on this federal probe, that the Norfolk DA believes that there's a number of conflict of interests that the DOJ failed to recognize and that they're essentially targeting him. So we did a public records request for that letter. And when I got the denial from the Norfolk County DA's office, they denied it, saying, hey, this is confidential information. We don't have to give it to you. That essentially confirmed for me that, yes, we do have this letter in existence. This letter is here.
So at this point, where does everything stand? Do we have any idea whether or not people have been interviewed? Have people given depositions? Have people been put in front of a grand jury? What level of investigation is this federal probe at? Do we have any idea?
We do. Our sources tell us that there is a federal grand jury. We know subpoenas went out, and it's been going on for a long time, that subpoenas, at least one round of them went out on April 10th. A number of people who the state has identified as witnesses, who are going to be witnesses for the prosecution, they've been called in to testify in front of this grand jury.
You don't think that he's not getting shit? You know, I think that, you know, and I don't want to get down on Ted Daniels at all, because you're doing a great job reporting this. But I think, you know, he gets a little bit of that cover under the umbrella because he's mainstream media. You know, it's like we're the independent people. We're the ones that get attacked, you know, a lot. We get attacked a lot. And I'm not saying Ted is getting a pass, but I'm saying it's easier to come at us than the mainstream media, you know.
And we know that the grand jury was hearing testimony over the summer. I'm aware of people who testified in July and August, but I have not been able to find or learn of anyone who's testified in front of that federal grand jury since August. And as you know, Vinny, these cases, the federal cases, they can take a really long time. But, you know, there's so much, I think, you know, thirst for information here that people are saying, hey, if the feds have something, if something really exists here that shouldn't, let's hear it. We want to know, because Karen Reed's going to be supposedly going to trial in March. I don't think it's actually going to happen then, but that's when she's on the calendar for.
Right. If the federal probe uncovers something, you would think that Karen Reed and her team would want to know what's going on there, because that would impact their case, because their whole case is that there was something wrong with the investigation and then it was some level of a cover-up.
Absolutely. It's hard to imagine that the feds would let the case go to trial if they have something, which we don't know if they do. If they have something, that the feds would let the case go to trial and play out that way, and then, you know, bring a resolution after that. Or if there's indictments, drop indictments after that. It just seems that there is, the timing of this is super important. And I wonder if the feds believe there is some pressure on them to wrap this up and reach a resolution.
And I want to get your take on what's happening at the courthouse, these huge displays. And I know I've had him on the show, Turtleboy. I know there's a
SC, thank you for the 5 through Buy Me a Coffee. I appreciate the support. Thank you. Appreciate it.
Bunch of turtle riders out there, his supporters, his listeners. But what's your take on this crowd?
Thank you.
Is this his crowd? Is this people from the city of Canton who've gotten wind of what's going on? Like, what is really the genesis and the makeup of all these folks that are showing up at that historical courthouse?
Nanny, thank you so much for the 15 through Buy Me a Coffee. I appreciate it. Thank you for the support. I really do appreciate it. Thank you. Thank you so much.
Well, Turtleboy's done a really good job of sort of galvanizing this large group of people. And I wouldn't say these are necessarily Cantonites. These are people from all over Massachusetts. And these are people who are incredibly passionate about their belief that this is a cover-up and that Karen Reed has been framed, and they're all over the state. You know, we cover a bunch of stories, but this is the story that people always come up and ask me, hey, what are your thoughts on this? What have you heard about this? There's something about this story that's just caught the attention of everyone here in Massachusetts, and I know that there's national interest in it too.
Oh, big time. Big time. So I want to take, since I have you here, I want to take advantage and go through some of the evidence in this case with you and get your take on this evidence and anything else that you know about it. Let's begin. I want to take a listen. This is Adam Lally, District Attorney, talking about the cocktail glass evidence, which I think is extremely important for the prosecution.
You know, I just want to go off this chat real quick. Greg says, great people, informed people, caring people. I have to agree. You know, like I said, I went out to Turtleboy's hearing on November 1st. I was out there, and I couldn't be more welcomed. People were just great. They came right up to me. They're like, hey, I know who you are. And I was kind of like shocked. I was like, you do? And they're like, yeah, we've watched your streams, and you know, thank you for covering this, and thank you for doing what you're doing. And people were just really great, educated people. It was just really, really welcoming.
The damages to the right rear corner panel of the defendant's vehicle. Embedded within the bumper to that vehicle is pieces of a cocktail glass. The victim, Mr. O'Keefe, is last observed on surveillance video, external surveillance video from the Waterfall establishment that he left just prior to going to 34 Fairview, with a cocktail glass in his right hand. Same arm.
How is that even? I just don't understand how that's even possible. So you're holding a glass in your hand, and then a SUV that's backing up at 62 feet at 24 miles an hour is just going to run you over, and then just magically going to turn around and go, oh, the cocktail glass is going to get embedded in the bumper. How does that even happen, considering all the damage that supposedly this SUV backing over him did to John? It absolutely makes no sense. Absolutely makes no sense. It literally makes no sense.
Injured, the same type of glass that is then recovered from the bumper of the defendant's car.
So Ted, what's your take on the significance of this cocktail glass and the fragments that were allegedly found?
Yeah, the prosecution needs a way to explain what appear to be those puncture wounds on John O'Keefe's arm. And it appears that this might be a way that they're going to go about doing this, that John O'Keefe had this cocktail glass, and when he was hit and it broke and somehow shattered or somehow dragged his arm. You're looking at the picture right there. And, you know, normally when something like having a cocktail glass would be that important, but I think as we see this case, when it goes to trial, I think that's something you'll be hearing a lot about.
And I heard the DA also, in the argument there, Assistant DA talk about pieces of the glass in Reed's bumper. So the prosecution theory is that she backs into him and then the glass breaks, ends up in her bumper?
Yeah, I mean, if they really do have a piece of glass that they found on her bumper, I think that's important for the prosecution. How else did it get there, Vinny? I mean, I think that is something that I haven't heard a ton about, but it seems like a very logical path that the prosecution would want to go down.
Now, the other big thing is the tail light. Let's take a listen to the defense attorney, David Yannetti, talk about her broken tail light, which is another big issue in this case.
The taillight was intact when she left Brian Albert's house. She came home, and this was Karen leaving to begin the frantic search for John O'Keefe. Now, I don't know that you can see it from the video that you have there, but there is no doubt that when
I zoomed in.
SUV comes into contact with what is John O'Keefe's vehicle parked in the driveway, you can see that rear tire move forward. It rotates, and you also see the light shatter from the taillight being broken.
Jody, thank you for the 15 on Cash App. Thank you.
So I guess this is another issue in this case. Like, how does the tail light break? Does she smash it the morning after, or does she break it when she is running over and intentionally killing John O'Keefe? This will be significant as well.
Oh, I'm sure they got something like this, JW, already. I'm sure they do. I believe me. They're going to recreate everything. They're going to get out and show how it's impossible. The 62 feet, they're going to show all of that, how impossible this theory is. Believe me. It's going to be crushed. And I'm guarantee you they've already done something probably even better than I've done with blowing up that area of the car and showing Karen's SUV lunging forward and actually seeing John's SUV move. I mean, it just clearly shows it. And then as Karen's SUV drives away, you can see where her light was actually cracked because it's not illuminated, because all those lights on the back are LED. So I mean, I can't. You can't. I'm sure they already have something better than what I've done.
I spoke to Karen Reed's
And
parents.
wouldn't it be something, though, if they play my video in court? That'd be great if they use it. Look, here's an enhanced video, ladies and gentlemen of the jury.
I did a sit-down interview with them a few months ago. And one of the questions that I asked her parents is, did Karen say she hit something? Does she remember hitting anything? And they said, yes. She said to her father, I thought I may have hit something. And their explanation is what you're looking at here, that Karen Reed backed into John O'Keefe's car that was parked in his driveway there. And they're saying, yeah, the taillight's broken because that's the way it happened here. The prosecution, if you look at their filing, they'll say that it appears that it may have touched the car, but it didn't really, move the car. We actually took a real close-up shot of that and spot shadowed it and slowed it down. And it does appear, as David said, that the tires do appear to move forward a little bit. Would that be enough to cause the taillight to break? I don't know. I'm not an expert on that. But I know that is certainly huge for the defense, this video right here.
Yeah, like what are the odds that you're accused of running someone over with the back of your car and later that same morning or a few hours?
You can see her light right here. It's cracked. And the light is out.
Later.
Look, it's right there. Look at the other light, fully illuminated, fully illuminated. Look.
You back.
There's a better shot of it right there. Look, I just don't know how hard that is to figure out. I mean, even just to the layman's eye looking at this, you can see the break in the brake light, the crack. Look at fully illuminated on the driver's side. On the passenger side, right here where that black spot is, that's where it was at. It's so easy to figure out.
Into
Look,
a vehicle.
And you can see it here. It's still fucked.
It's going to
right there. At the very last second, you could see it was fucked.
Be difficult for the jury to deal with that. Now, the big thing, I know this is what set off Turtleboy when I spoke to him, which was this Jennifer McCabe Google. Jennifer McCabe, one of the women at the party that night. Let's take a listen to Alan.
Again, we don't say their names in the chat. Let's just be, the witnesses. We don't say anything about the witnesses.
Jackson described that piece of evidence.
Why is Jennifer McCabe?
Let the lawyers say it. Let the lawyers say it.
One of the parties that was inside the house that night, the sister-in-law of Brian Albert. Why was she Google searching? How long does it take for a human body to die in the cold? The Apple Cocoa core data indicates, or the core time indicates exactly what time that Google search occurred. That time was at 2:27 and 40 seconds in the morning on January 29th. That's 3.5 hours before John O'Keefe's body was found.
I think for many people who believe that Karen Reed is framed here, this is the smoking gun, right? The allegation that there's a search about how long for someone to die in the cold at 2:27 in the morning before John O'Keefe is ever found.
Yeah, that's what that's what the defense led with. I remember the first day that they announced this bombshell change in the case, that is the evidence that they said they had. If you talk to the prosecution, they will tell you that there was a tab that Jennifer McCabe had open, and she opened that tab, and the search was actually conducted in the morning. And what the prosecution is saying is the search was conducted at the request of Karen Reed. So, Karen Reed is the first one to see John O'Keefe's body on the lawn. She's with Jennifer McCabe. And according to Jennifer McCabe, Karen Reed frantically yells, "Search, how long it's snowing? How long does it take to die in the cold?" And Jennifer McCabe went ahead and searched that. I've spoken, I dealt with Celebrite and some of the other cell phone analysis companies. I've shown them this evidence, and I'm like, tell me what you think. And nobody is willing to go on the record and say whether or not they think that search actually happened at 2:27 in the morning, or if that search happened later in the morning when there were other similar searches for how long to die with cold.
That's unbelievable. That is such an important part of this case, and the experts are not going to agree at trial, because I'm sure both sides will have experts that won't agree, but it seems like there's no real consensus in the business as to what it means. Unreal. Ted Daniel, so happy you could be on the show tonight. I hope we'll speak again as the trial gets closer. Boston 25. If you don't live in Boston, go online and check out the stories. Amazing, amazing work. Thanks so much, Ted.
Thanks, Vinny. Good to join you.
All right. Good stuff. I hope this, I hope this was educational today, and it was a refresher for everybody for why we're here and why we're supporting this movement. Friday, again, we all need to be strong. We need to be peaceful. You could go there and show your support. We're all going to be in support, and we'll keep the movement going. Keep this movement going. And I'm telling you, it's just, when I first saw this from day one, I'm like, there is I didn't even know. I wasn't even digging in. I was just watching videos on it. I'm like, there's so much reasonable doubt in this case. I mean, the facts are there. And, again, I'll be out there on Friday reporting. Hope that I get to see some of you all. I will do, obviously, a couple more streams before Friday to keep the movement going. And I look forward to being out there and reporting on this case. And again, I appreciate everybody being here this afternoon. you know, we need to keep this movement alive. We need to do it peaceful. Go out there and support Karen. Go out there and support justice for John O'Keefe, and of course for Turtleboy as well. And you know, continue to spread the movement. And we'll see what happens. I think the hearing on Friday is going to be very, very interesting. Very, very interesting. Before we go out, Paula, thank you so much for the new membership. The Galera came in. Happy New Year to you as well, man. Thanks for the $9.99. Babs, a new member as well. Danielle, thanks for the $4.99. I appreciate it. Paula with the gifted, thank you. And we have Micro Kimmy with the $1.99 again. I put out 5 memberships as well. Get some new members out there, and Carrie with the gifted 5. Thank you. And everybody that came through on Cash App, Venmo, Buy Me a Coffee, I appreciate it. And you know, we'll keep moving the movement along here, the Free Karen Read movement. I will be back tonight at 8:15 p.m. Eastern Standard Time. If anybody wants to join, please do. We're going to do an update on Chelsea Grimm's case. I'm going to have Steve from SF Investigates live on my panel. He was just back out in Williams for a couple of days doing some drone mapping of the area of where Chelsea went missing, and we'll get maybe some new photos or some new video as he was out there. And of course, we'll give the most latest update and refresher on the last that we know of that case, because it's been quite a while. We haven't had any updates, and it's sad. It's sad. Chelsea doesn't deserve this. Chelsea deserves to come home, and we're going to keep pushing that forward, that she does come home. And then after that, I'm going to take a little bit of break and then be back at 11 p.m. Eastern Standard Time. Super casual stream. You're all invited if you want. Not sure of your plans tonight. I will be in tonight, hanging out here at home. I don't go out on amateur night, but if you want to come hang out, just watch the ball drop with LTL, you're welcome to do that. If not, I wish everybody a very happy new year. I can't wait to see everybody in 2024. I think it's going to be an amazing year. And let's do this before we go. Let's see some turtles in the chat for Turtleboy, and let's see some red and blue hearts in the chat for Karen Read and John O'Keefe. And we'll go out with that today. Again, I appreciate everybody again for being here. We'll give this a moment. We'll watch some of these turtles hearts come through, and then we'll end the stream. Awesome. Love the support. It's what we need. It's what we need right now. I love the support. I'm going to free the chat up to let it flow a little bit easier as we wind down and head out for the rest of the day here for a little while. We'll take a break, and then we'll be back. Let them flow. Love it. Good stuff. All right, everybody. Have an amazing afternoon. Thank you all for being here. I know this is early in the afternoon, and I know a lot of people are out making their plans and getting ready to get to do things. But if you do go out, again, please be safe. Don't drink and drive. If you've been drinking, get a friend to drive you home that is sober, or call a rideshare service. We want to see everybody be back here in these chats supporting. I don't want anybody getting hurt or locked up. That's the most important thing. So thank you all so much for the support. I'll talk to everybody soon. Have an amazing rest of your day, and hope to see you back tonight. If not, have a happy 2024. Celebrate in the in the way that you do. Take care, guys. Bye-bye. And ladies, take care. Bye-bye.